Hi, my name is Andrew Meinzer of Meinzer Law Firm. This video is the second in a series regarding probate decedents estate court proceedings in California. In the first video, we covered the ultimate goal of this process, which is transferring the assets of someone who died, a decedent, to the people who are supposed to receive them. We also touched on the steps. Remember that there are three major steps of a probate decedents estate court proceeding. Number one is getting someone in charge of the assets of the decedent. Number two is paying the valid debts of the decedent. And finally, number three is transferring legal ownership of all of the decedent's assets, or the estate, to others. In this video, we're going to focus on that first step of getting someone in charge of the assets. So the first thing we need to do is file a petition and related documents with the court. A petition is simply a document filed with the probate court requesting that the court take some action. Through the petition, we ask the court to put a specific person in charge of the proceedings. And here, our job is to guide that person through everything. I'll assume for purposes of this conversation for now that you are that person. When we file the petition, the court will set a hearing date and time, which should be within 60 days from the date when we filed the documents with the court. We need to take certain steps prior to the court hearing of the petition, or else the court will not approve it. These steps are designed to ensure that anyone with any potential interest in the assets is aware of what we're asking the court. And you'll notice that some of these requirements are a bit outdated. Prior to the court hearing, we need to mail notice of the hearing and a copy of the petition to all heirs of the person who died. Those are his or her closest living relatives as defined by California law, and to all beneficiaries of the will if there is a will. The notice tells these people when and where to go if they have information that they want to give to the court. Also, notice of the court hearing needs to be published in a local newspaper. We make this happen through a local publisher. Believe it or not, the idea is that in the age of Facebook and Twitter, people actually read newspapers to find out about deaths. I know. And then we need to file documentation with the court letting it know that we mailed and published the notice as required. If there's disagreement regarding who should be in charge, then someone may come forward and formally object to the petition or even file their own competing petition asking for the court to put somebody else in charge. In that situation, a mediation or trial may be required. All of this slows down the process, of course. Fortunately, most probate decedents estate court proceedings don't go in this direction. If there's no formal objection or competing petition, then the court ordinarily will appoint you to be in charge as requested. Now you're in charge of the assets of the decedent. The court will generate two documents that will be your proof of your authority that you're in charge, and we will pick up with the rest of the subject in the next video.